The Court of Appeals is now in session.
Good morning. Welcome all. The court will actually consider three appeals this morning. In your case, we thought that oral argument would be of material assistance to our consideration of the matter, so we're glad that you're able to join us this morning. Rumor has it, Ms. Webb, that this may be your first argument.
Rumors are true.
Okay. Well, then I probably should have characterized it more as a report than a rumor. Anyway, welcome. We have sort of a 101 level introduction and then a 301 level. We'll do the 101. Although most of the 101 is focused on what's different here than in the regular courtroom. And if you've never argued in the regular courtroom, that's not the best possible frame of reference. One advantage that we have found in doing the oral arguments virtually is that we don't have the distractions of the courtroom. We're able to focus on the attorney that is at the virtual podium. And to that end, we do ask that when counsel are not arguing, that they not only mute their microphone, which we should all be doing when we're not talking, but also turn off the camera so that we can focus just on the attorney that is at the podium. And then, as I often point out, that leaves other counsel free to roll their eyes, shake their head, go get a cup of coffee, take a quick phone call, whatever. We don't know what's going on if it's off camera. So we will ask you to do that, and we're happy to remind you if it doesn't happen as a matter of routine. The main lesson for the judges is that we don't have the opportunity as we do when we're on the bench to judge from body language and through our peripheral vision who's about to ask a question. And so we're consistently trying. I don't always succeed, but it is our hope that when a judge has a question, we'll raise our hand. And we don't expect you to stop mid-sentence to take that question. But as I'm sure your colleagues have told you, often the very most important part of oral argument is getting the judge's questions answered. So come as quickly as you can to a convenient breaking point, take the question. There may be a follow-up, but if you would be mindful of that, we would appreciate it. Occasionally we have a technological glitch, even more so here than in the courtroom. The time on the clock is a little bit advisory, and if we have to do a rewind, reboot, start over, back up, sorry we missed the last 4 sentences, we're happy to do that, and don't be concerned that would be counted against your time. Finally, it's helpful should we have occasion to go back and listen to these arguments, if not only initially, but each time you come to the podium, you will either state your appearance or remind us of your appearance, so that if we have occasion to listen to some part of the argument, it's always immediately available to us who is saying what, when. Any questions about any of that? Excellent. Then why don't I have you both state your appearances for the record, after which we'll ask Mr. Von Mock to step away and we'll hear your argument, Ms. Webb.
Taylor Webb on behalf of appellant Sarah Ward.
And Chris Von Mock on behalf of appellee and defendant Meredith McGarry.
Very good. Thank you both. We'll see you in a few minutes, Mr. Von Mock.
May it please the court. My name is Taylor Webb on behalf of appellant Sarah Ward. I'd like to start today by addressing the dismissal of Ms. Ward's breach of contract claims. Ms. Ward alleged a breach of contract and sought non-economic damages as her recovery for that claim. The district court ultimately dismissed the claim on the basis that non-economic damages are unavailable under this contract. But if non-economic damages aren't available under this contract, it's difficult to imagine a contract where they might be. The test for the availability, sure, yes, Judge Shulman?
it occurred to me that conceptually, it's not that hard to imagine. Let's suppose that both Ward and McGarry had worked for the same employer, and the employer had a strict policy against sexting, and the concern of Ms. McGarry was that those photos would be shared with the employer and she might be terminated, losing her job and her stream of income. Well, that's very much an economic kind of a loss. And if that were the context in which this contract arose, one could see that there would be an appropriate focus on economic loss. I gather, though, our context is nothing like that. Could you develop that point? I'm sure you were headed that way. Anyway, I just wanted to make clear that my own perspective is thinking about economic loss is not necessarily bizarre, but possibly inapplicable in this case.
Sure, there's certainly a different context in which this contract could potentially give rise to some sort of economic loss, but the purpose of entering into this contract was to prevent exactly the harm that Ms. Ward has now suffered, which is the emotional distress of Mr. McGarry's continued possession of her nude images after the breakup of their relationship. So there is no sort of economic component to this contract. The only purpose in entering into this contract is for Ms. Ward to be assured that Mr. McGarry no longer has possession of these images. And the test set forth under Cranendonk requires that we be able to look at both the nature and the language of the contract to determine whether the parties contemplated non-economic damages. And there's no dispute, the district court concluded that the nature of this contract satisfies the Cranendonk test. The only issue is as to the language of the contract. But I think that your question highlights the fact that the analysis under Cranendonk needs to look a little bit different depending on the different types of contracts. So where you have a contract that is more traditionally the commercial contract between two parties, arm's length negotiations, fully executed document, you're going to need to be able to point to specific language in the contract that demonstrates that, unlike every other commercial contract, these particular parties did contemplate non-economic damages. But where you're on the other side of that sort of spectrum, as you are here, where the contract itself is by its very nature purely and particularly personal, I think that's doing a lot of work in the Cranendonk analysis, and it's difficult to see what exact language you would need to be able to point to that does more work than the nature of this contract itself. I think under Mr. McGarry's reading of Cranendonk, the contract would have to say something like Party X is entitled to non-economic damages in the event of a breach. But that's not the test, because if that were the test, that's just applying the plain language of the contract. And if you, for example, had an oral contract, there would be no language in particular to point to. But to the extent that you need to rely on some specific language, the language of this contract is there's two former intimate partners, one of whom is requesting that the other delete the nude images of her. That's purely personal, and emotional harm is contemplated by that agreement. Yes.
Ms. Webb, how do you respond to the two footnotes in Cranendonk 28 and 34 that seem to disavow that language in Cabanas that suggested that you didn't have to have you don't have to have express language in the contract? I mean, footnote 28 specifically says, so while we do consider the expectations of the parties when determining damages in the breach of contract context, we consider only those expectations that are apparent from the language of the contract. How do you get around that? Isn't Cranendonk pretty clear about that we do need some express language?
Sure. I think that the interaction between Cabanas and Cranendonk can be explained in that in Cabanas, the nature of the contract was an employment contract that had a provision prohibiting discrimination. And the court in Cabanas held that language was sufficient to create a dispute of fact, sufficient to withstand a motion for summary judgment. And what Cranendonk clarified is that the Cabinet's court did not say that that language was sufficient as a matter of law to entitle the plaintiff to non-economic damages, but it's sufficient to create a dispute of fact. And if the language in Cabinets is sufficient to create a dispute of fact, sufficient to withstand a motion for summary judgment, the language here is sufficient to withstand a motion to dismiss. Ms.
Can I ask
Judge
a
Morris.
question about that? I actually read Doc differently. I think what the court there is telling us is that we have to actually look at the four corners of the agreement, that we shouldn't look outside of it. And to the extent Kavanagh's did, Kavanaugh's was an error and the court was repudiating perhaps what it had done in that case, excuse me.
Sure. I think that if you look at the four corners of this document, the four corners of this document are Ms. Ward's request to Mr. McGarry to delete her nude images. And it's true that that does not say in the event that you refuse to delete them or do not delete them, I am entitled to my emotional damages. But again, the only harm that could stem from this, the only harm contemplated by this contract is non-economic harm. And as the Shealy court the case cited in Cranadoc Shealy, the 11th Circuit case, non-economic damages are particularly appropriate where emotional distress is the only alleged damage to the victim, the only available remedy to make good the wrong done, and the only way to put private parties in as good a position as they would have been had the contract been performed.
But I think if we were in the 11th Circuit, I would agree with you, and I think you'd be right. The problem is our Supreme Court seems to have required an additional element. And I think in order for us to agree with you here, we would have to say that Cranadoc doesn't really apply to this kind of a contract. That it's so brief, it's so small that, there's really nothing in there for us to really glean information from. And so therefore, this additional requirement that Cranadoc recognizes and requires, we're going to decide it doesn't apply here. Otherwise, I'm not sure we can find in your favor, because I think Cranadoc does require something else, and perhaps our Supreme Court didn't anticipate a contract like this. But tell me if you think I'm right about that. I mean, can we apply Cranadoc and still conclude that you should get a reversal here?
Yes, I think that you can. I think that this would be a different question if we were talking about a purely commercial transaction. Then I don't think that we could seek non-economic damages in that case. But as Mr. McGarry's counsel even noted in the record at 164, this is not a breach of contract where the two parties agreed to a bargain for exchange for services or for a product that was not delivered, where one could readily ascertain economic damages. This is a non-economic damage and emotional damage, and the law can recognize that under the proper circumstances. And these are the proper circumstances. The only motivation for entering into this contract was to prevent the exact harm that Ms. Ward has suffered, and that is emotional harm. There is no economic component to this contract. There is no purpose to entering into this contract if Ms. Ward cannot receive damages in the form of emotional distress. And with that, I'd like to spend a little bit of time talking about the economic loss rule, and unless the court has any further questions on the breach of contract issue. As to the economic loss rule does not preclude Ms. Ward's tort claims because she has alleged an independent duty that Mr. McGarry breached. The breach of the contract was Mr. McGarry's failure to delete the nude images. The breach of the independent duty was his display of those images to third parties, including his son. Yes.
Do you agree that that's not alleged in the complaint?
I don't.
Okay, so tell me what paragraph it's alleged in.
In the complaint at Record 4, Ms. Ward alleges that Mr. McGarry made the pictures available to others. That's clarified at the hearing on the motion to dismiss, where Ms. Ward alleges that this includes a duty not to display to specifically children, which would be a subset of just generally the duty to refrain from displaying to third parties.
But the argument at the oral argument, I mean, the court was very specific. She wanted him to identify a duty. And the only duty he identified was a duty to not harm children, which is a different duty than to just not disclose to the public generally or to anyone generally. And so even if I was to agree with you that perhaps that is an appropriate duty, it's not the duty that was identified to the district court. And so is it appropriate for us to give you a reversal here where we would be deciding that maybe that duty applies, but it's not the duty that was identified when the court asked for one in oral argument?
Yes, Your Honor. And I believe that what the specific duty that was discussed at the hearing is in fact a subset of this broader duty. And while Ms. Ward was not obligated to bring forth every particular or every possible duty, but the existence of an independent duty, regardless of which independent duty we ultimately rely on, was brought to the court's attention. The court ultimately ruled on it and concluded that she had not satisfied that test. But Ms. Ward alleges the independent duty in the complaint and here by nature of Mr. McGarry's conduct in displaying these images to third parties. And even at the hearing, the allegation as to displaying the images to the children, Ms. Ward's counsel noted that caused harm to both the children and to Ms. Ward. So it still alleges a duty that Mr. McGarry has breached. And I think that duty is recognized in the case law that we cited in the brief. And also it's instructive that there's a criminal statute that recognizes that this conduct is criminal in the right circumstances. And that criminal statute, importantly, it includes a broad definition of what it means to distribute images, and that includes providing, giving, granting admission to, providing access to, or otherwise transferring or presenting an image to another individual. And the complaint alleges that conduct. And it's true that, the criminal statute is not dispositive. We don't need to satisfy the criminal standard, but the fact that that duty exists in the form of criminal statute lends support to the existence of that duty in tort. If the court has no further questions, I see that my time is about to expire, so I will resign.
Thank you very much, Ms. Webb. We will hear from the other side, and then we'll have you back for 3 minutes of rebuttal.
May it please the court, Chris Von Mock on behalf of appellee Meredith McGarry. I'll take them in a slightly different order. I'll take the last argument first. This is the economic loss rule. I think it's undisputed that the economic loss rule applies here absent the articulation of a recognized independent duty. In fact, Ms. Ward states in her opening brief, this case arises out of an agreement concerning nude photos that Ms. Ward sent to Mr. McGarry when they were involved in an intimate relationship. I believe they are correct. That is what this case arises out of. And insofar as the recognized independent duty, no recognized independent duty was identified either in the complaint, in the briefing below, in the oral argument below. And so what we have here is appellate on appeal. The duty is articulated as a duty not to show or display these images to third parties. Judge Pullman accurately noted that at least that, well, I won't say she noted, she raised a question, and I will answer that to say, no, it is not alleged that there was any showing. So even if we were to say that there is such a duty as articulated by appellant, Ms. Ward, that was not alleged below. The preservation issue here is, I don't know how frequently it comes up with your honors, but it is mission critical that it be preserved. The reasoning for that, as articulated in the 438 Main Street case cited in the papers, is that it is axiomatic that a reviewing court, even in a de novo situation as we have here, must review the same arguments and allegations that were before the trial court. Unfortunately, Judge Chon was not provided this articulation. And if you say, well, gee, Mr. Von Mock, show me in the record below where the discussion was about whether or not this duty, which no one has pointed to any authority that it exists in Utah, how we should, as a court, adopt it. We would look to the BR case. That's a Utah Supreme Court case where Justice Lee, in his opinion, articulated sort of the 5 factors that are to be considered when a court formulates a new duty. And of course, below, there's no reference to BR, let alone the kind of important, detailed analysis that would be required to recognize this duty. So we have fundamentally a preservation issue, and then secondly, a failure to allege it as it's been articulated. And the next, I would also note that with respect to the scope of the contract, the Greinberg case and the KTM case cited in the papers stand for the proposition of what is the nature or the scope of the contract, if you will, kind of like a black hole the claims that might get sucked into the economic loss doctrine. And the Grindberg case says when the parties' difficulties arise directly from a contractual relationship, the resulting litigation concerning those difficulties is one in contract, no matter what the words the plaintiff may wish to use in describing it. And that's at paragraph 45 of that case. The KTM case uses the term part and parcel. And so, but for this agreement, there would be no independent duty by Mr. McGarry not to show these photos to third parties. Now let's talk about how oh, yes, Judge Pullman, sorry.
Let me ask a question about the Maurer case, which I think it's cited in one of the briefs, although it doesn't receive a lot of attention, but it does talk about how we all have a duty not to engage in intentional torts, right? We have a duty not to intentionally cause emotional distress. So whether that's about photographs or something else, isn't that a duty we all have? And if that's the case, doesn't at least the intentional infliction claim survive because it is reflective of, it's an allegation that someone intended to cause emotional distress?
Great question. Had that been raised below the response, which it was not, the response would have been this. Yes, there is an independent duty not to inflict intentional emotional distress upon others. And that is why we have the tort claim of intentional infliction of emotional distress. Were these parties strangers to contract, i.e. not in privity of contract, that would be a perfectly acceptable cause of action. But here, and this is where the economic loss rule comes into play, they are not strangers. They are not strangers, and of course they weren't strangers to begin with in the non-legal sense, but they are no longer strangers in the contractual sense. They are in privity of contract. And the thrust of the economic loss doctrine is we exempt from the realm of tort breaches of a duty that is established once parties have contracted around it, and that is their opportunity. It is a benefit and a burden. And so I was thinking about some of the arguments raised by Ms. Webb, and you say, well, what possible language could have been in this admittedly very short agreement that might have given rise to the language component that would exempt it? I know I'm conflating a little bit, but the Cabinets case, for example, if we had the language there. Now, where intentional infliction of emotional distress would arise and go outside of the scope of the contract is, frankly, none of the cases cited by Ms. Ward for the proposition that there is an independent duty not to show nude photographs to others actually stand for that proposition in the context of contract. Those are all the singular case in Utah was a civil stalking injunction case where one of the elements to obtain a civil stalking injunction is that a reasonable person would be likely to suffer emotional distress. And so that's the hook there. And in the other ones, it's a parade of horrors. You read those cases. It's literally hundreds of inappropriate communications, falsely identifying the plaintiff on social media sites, soliciting sex, putting out her contact information in an effort to break up relationships, cause injury to her employment, those types of things. And so, Judge Pullman, where the context rises to that level, you have now gone beyond this potentially in a situation where if you didn't have a contract, you'd certainly be in the realm of intentional infliction of emotional distress. But even perhaps in the context of the contract, but here we don't have that because the alleged conduct is nowhere near approaching that. And unfortunately, Judge Chon did not get a chance to consider that argument because that duty, as is being articulated now, was not alleged. Sorry, I hope that answers your question. I see Judge Christensen Forrester has a question.
Help me understand if the connection between these two arguments, the breach of contract the contract itself needs to expressly contemplate emotional damages, non-economic damages. And here we have a situation where if the parties are in privity of contract, that excludes the emotional damages because of the contract. Aren't we saying that? Aren't those two thoughts in competition?
They're only in competition because of the economic loss doctrine. When you have the contract, I mean, we have contracts where otherwise cognizable claims or remedies or species of damages are obliterated through exculpatory or hold harmless clauses. For example, clauses that limit consequential damages, punitive damages, and the like. And so it's apparently, at least in Utah, we're sort of in uncharted territory where you've got a contract that is governing the subject matter, and then and then you have all these allegations of tort around these images. So the answer to the question is, I think that once they enter into a contract, they're governed by contract damages and absent a recognized independent legal duty. And so I would, although it's not been argued or decided where there is a contract, what independent duty might exist outside of that. Judge Pullman's pointed to the general no intentional infliction of emotional distress duty. Sure, but when there's a contract directly on point, it covers it. Here's an example. What if the parties had entered into a settlement agreement related to these images, and then there was a breach of that, and Ms. Ward sued? Her remedies would again be pursuant to the settlement agreement, which typically is, rescission or enforcement of that. And Ms. Ward also comments about, hey, if there's no non-economic damages here, either there's no contract or the promissory estoppel claim should be resurrected. Not so. Specific performance was a available remedy. Nominal damages was an available remedy. Had she sought the device to then have it deleted by a third party and sought the damages as a consequence of those actual damages, having a third party delete those images, those would be recognized. Those would be available damages, but that is not what happened here. Instead, Ms. Ward, for the breach of contract, chose exclusively non-economic emotional distress damages of $100,000 or greater, I believe is what it was alleged. And so that is where that's the environment in which we are in. So if we were in a pure tort context, Judge Pullman's question is a good one, although I think that Judge Chon would have ruled as a matter of law, as is her right, to say that it was not the extreme and outrageous conduct, because certainly I could find no case, and I don't believe that the appellant could find a case that stood for the proposition that this singular making a device available that contained these images gave rise to the outrageous utterance that is typically required for such a claim. So I hope I've answered your question, Judge Christensen Forrester.
Can I ask a follow-up a little bit, or at least the same area as this discussion? Cranendon tells us we need to look at the express language of the contract and discern something from that. Is it possible the Supreme Court didn't anticipate this kind of a contract, right? I mean, I think when you read that case, you kind of see that it anticipates looking at, a 10, 15-page agreement where the parties have spelled out their duties and obligations. And so it's looking to see from that language whether it can discern that the parties may have contemplated this kind of damage. But here we have it. Is it a text message, right? Is that the nature of this agreement? That's what I understand from the allegations, Judge Pullman. Another great question. And the answer to your question is no. All of the analysis, including the 11th Circuit analysis cited in Cranendonk, is all in the nature of the contract analysis that spans paragraphs 33 through 34 of Cranendonk. It is paragraph 35 of Cranendonk that delves into the language piece. And remember, Cranendonk went into great detail about cabinets. And so cabinets was an employment contract, which, ostensibly didn't have a personal, it was pecuniary in nature, ostensibly. But they, and in fact, same thing with Cranendonk, right? That was sort of the latch on. They said, look, hey, you have a problem here with the nature element. Here, nature is not an issue. It was found by Judge Chon that the nature of this agreement is inherently personal in nature when we would satisfy the first element of we call it the Cranendonk standard. Cranendonk seems to suggest that cabinets wasn't inconsistent with it, but wanted to avoid the very arguments that we're having here.
But on the language piece, the court goes out of its way, and cabinet says language too, nature and language. And so if the Utah Supreme Court wanted to say it's actually nature and language, but when the nature is obvious, then language doesn't matter. They could and would have said that, but they went out of their way to say, hey, you can satisfy the nature, here, check. But then we got to look to the language, here, no check. And I've given an example of the type of language that might have, if it had existed and been pleaded, would have been sufficient. And that's the cabinet's language, right? Which the Utah Supreme Court said was sufficient to survive a motion for summary judgment. That was the employment contract said that the employer would not tolerate verbal or physical conduct by an employee which harasses, disrupts, or interferes with another's work performance, or which creates an intimidating, offensive, or hostile work environment. There, the court said, disputed issue of fact will remand to the trial court to figure out whether that satisfies the language piece and perhaps the nature piece. So, no, the short answer to a very long, but the short conclusion to Judge Pullman's last question is no. Two distinct elements, and nature satisfied here, nature not satisfied, and language not satisfied. And the fact that it's arm's length, that it's negotiated, whether you have attorneys or not, there's reference to that. I think it's kind of like, you're a trial, if you're an appellate court judge or a trial court judge, you want to buttress your argument with as much as you can. But I would contend that any arguments around the importance of the sophistication of the parties, the involvement of attorneys, the length of the negotiation, that's really just all dicta, because what the elements are twofold, nature and language.
Thank you, Mr. Von Mock. We appreciate your argument. And Ms. Webb, the virtual podium is again yours for 3 minutes of rebuttal.
Thank you, Taylor Webb, again on behalf of Appellant Sarah Ward. I'd first just like to highlight the importance of the procedural posture that we're in here. This is on a motion to dismiss. So to the extent that any of these arguments are relying on a failure of pleading, Ms. Ward's complaint then should have been dismissed only without prejudice, with the opportunity to amend and reallege as to satisfy those concerns. As to the contract claim, the Crandock standard cannot be read in the way that Mr. McGarry's counsel is asserting. Insurance contracts, for example, in Beck is where the court recognized the availability of emotional distress damages even in contract claims, and insurance contracts never contain language that discuss emotional distress harm, but nonetheless we recognize the potential availability of non-economic damages arising out of those cases. And I think the language that Mr. McGarry's counsel just read to you from Cabinets, that had nothing to do with non-economic damages. It had to do with the type of contract that was at play and the type of harm that was contemplated by that contract. The existence of a non-discrimination or non-harassment provision doesn't discuss non-economic damages. It's that we understand that the result of a breach of those provisions results in non-economic or emotional harm. And the same is true here. We don't need language in the contract saying that if Mr. McGarry doesn't delete these images, I will suffer emotional harm. We understand that if Mr. McGarry doesn't delete these nude images, Ms. Ward will suffer emotional harm, and that is sufficient under Crandock. As to the economic loss rule, I think the fact that these duties are independent under tort, and that's clear because if Mr. McGarry and Ms. Ward had never had a contract, we would still be bringing these tort claims. The existence of these tort duties do not depend on the contract. Mr. McGarry had an independent duty to refrain from displaying these images, even if Ms. Ward never asked him to delete those photos. And as to the cases cited in the briefing, I acknowledge that those cases do discuss much more egregious conduct. But the egregiousness of the conduct is a separate consideration from the existence of the duty. And those cases, regardless of how egregious the conduct is, demonstrate that this duty exists. And Mr. McGarry's conduct, even if it does not rise to the same level, is still a breach of that duty. But again, the question on the motion to dismiss is the existence of the duty, and the duty exists as demonstrated by those cases and in reference to the criminal statute. So even if Mr. McGarry's conduct does not rise to the same level as those cases, that doesn't mean that the duty doesn't exist. It's just a question of breach. And I think this duty, as we discussed, was raised to the consciousness of the court. It was in the court's order. The court considered this, and so it is also properly preserved. If the court has no questions, I'll submit.
Thank you, Ms. Webb. Mr. Von Mock, will you join us again on screen? Speaking only for myself, I did find that the oral arguments were helpful to my understanding of the matter, despite in my question having mischaracterized which party was which, with my notes covered with notice of the hearing. And Ms. Webb in particular, I think you can feel that you acquitted yourself well. Had I not known that this was your first argument, I would not have jumped to that conclusion. You did an excellent job. And of course, Mr. Von Mock, on the strength of your considerable experience, you predictably did a very fine job. So thank you to both of you. Our time has been well spent this morning, and we will take the matter under advisement, let you have our decision as soon as we can get that taken care of. And with that, we will be in recess.